Good evening, everyone, and welcome to our constitutional law class. So next week, God willing, we will endeavor to meet physically so that we see your beautiful faces and smiles. But let's manage and do online tonight. So tonight we want to discuss legal effects of coup d'etats and revolutions. In other words, what is the legal effects of coups, coup d'etats, revolutions on the pre-existing legal order? That is to say that if there is a coup d'etat, if there is a revolution, does it affect the legal order, the constitutional order, which was existing before the revolution took place, or before the coup d'etat took place? So those are the matters that we want to be exploring in this particular class. And a very important point to note is that we cannot learn constitutional law in a turbulent region like Africa. Africa turbulent in the sense that there have been so many waves of coup d'etats, revolutions in the past, the 60s, the 70s, 80s, and even now that we've had so many constitutional democracies in the sub-region, we still see coup d'etat not too long ago, Niger, Burkina Faso, Mali, and so on. And our own country, we are not innocent when it comes to coup d'etat and revolutions. We've had our own share of it. If we look at our governance history, you will notice that you've had like a checkered history. Checkered history in the sense that we've had military intervention here and there. And the question which comes up is that when there has been a coup d'etat, what happens to the legal system, the legal order, which was in force before the coup d'etat took place? We often encounter these issues when we have litigation or dispute before the court. When the issues that are being litigated may be stemming from either the coup d'etat and somebody trying to use the old legal order to get a remedy, as it were. So that is a context within which we need to appreciate the relationship between coup d'etats, revolutions, and constitutional order on the other hand. Now, so we may want to understand, first of all, when we say coup d'etat, what is it? Revolution. Of course, as you notice, coup d'etat originally is a French word, but there's a scholar who did extensive work, and his work remains still authoritative or instructive in trying to illuminate our understanding of what coup d'etat or what revolution is. And for that matter, the legal effect of it on the pre-existing legal order. I'm referring to Hans Kelsen. Now, Hans Kelsen did a work, and he titled a very big work called The General Theory of Law and State. Now, later on, you'll be learning jurisprudence or philosophy of law, and be learning about some of the schools of jurisprudence. So you come across the pure theory, and that has to do with Hans Kelsen. So he belongs to the analytical component of legal positivism, and he sought to develop or propound a theoretical understanding of law in such a way that irrelevant materials, and by irrelevant materials here he's referring to things which have got nothing to do with the rare legal force, will be extricated from the search to properly explain or understand law. I mean, that is a story that we return to in the course of your legal education as you get to the final year in your doing jurisprudence, or the one teaching you Ghana legal system and legal method. There's a little bit of nature of the law. And if you take my volume 2 of the Ghana legal system and legal method, so there's a whole chapter on it. But having said that, Hans Kelsen in his work, General Theory of Law and State, attempts to make the point, and I quote, "The state and its legal order remain the same only as long as the constitution is intact or changed according to its own provisions," unquote. So this statement by Kelsen gives us a good insight. That is to say that if you have any change in your constitutional order outside the terms of the constitution itself, that is coup d'etat, so to speak. That is a revolution. So any change in the constitutional order, which is not pursuant to the provisions of the constitutions or the stipulation of the constitution, as it were, constitute a coup d'etat and a revolution, as it were. So we say that the state and its legal order remain the same only as long as the constitution is intact. That is, nothing has been done to the constitution. And the constitution remaining intact will mean that if you haven't changed the constitution at all, you are following the prescriptions and the stipulations and the remit of the constitution to bring about the requisite change. So that one, you still have the constitutional order in place. It's still intact. However, where you make changes which is not prescribed by the constitution, you have embarked upon coup d'etat against the constitution, a revolution, as it were. So coup d'etats are usually referred to as the unconstitutional overthrow of an existing government. So if you make effort and you succeed in overthrowing the constitution, that is coup d'etat. Now, as we know, coup d'etats are often associated with or characterized by violence for obvious reason. People trying to use force to capture power, and it will definitely not come easy. And if you look around the globe, the coup d'etats or revolution which have been bloodless, they are not too many, meaning that greater majority of coup d'etats or revolution would be associated with violence, bloodshed, and all that. So certainly, you notice it's not a good thing. And again, where you have coup d'etat, the top hierarchy of government officials are those who are immediately affected, especially the executives and the lawmakers, those who constitute like the government, the top officials, ministers, and all that. they are changed by the coup makers or the leaders of the revolution. Maybe if you take the courts, for example, when you have a coup d'etat or revolutions, you don't actually get the courts or the judicially being immediately affected, as it were. If you look at especially our own country, the various times that we have had the revolution, I think it will reinforce the observation that we are making. But if you wanted to maybe draw some distinction, one may say that revolutions are more popular based. That is to say that it is a uprising, general uprising of the masses, or like revolt. And maybe not too long ago, the Arab Spring, you remember the Arab Spring? And in the distant past, we also had like the French Revolution, as it were. So they have some kind of either spontaneity or widespread participation or reception. So that is how usually revolutions are. And if you take Ghana, there was a young man called J.J. Rawlings who in the past, of course, he's not a young man now, he died at a reasonably good old age. Now, he led a group of junior soldiers, as you remember, to do what they call the so-called June 4th uprising. Those days, they had what they call the AFRC, Armed Forces Revolutionary Council. Of course, as to whether that can properly be considered a revolution is highly debatable, because whether we can treat that as a general, revolt by the masses, as it were. Or can we say that what happened and enjoyed direct or indirect, that is express or tacit approval of the masses? Can we really say that? Well, that is something that at your level, you can keep talking about it and debating. So according to Hans Kelsen, any illegal change in the constitution of the state represents a revolution. So Kelsen's view is a bit more radical. So he is saying that if you have any change in the constitution of the state, and that change is illegal change, illegal in the sense that you did not follow the procedure for amending the constitution or bringing about the change, then that is a revolution, so to speak. So in terms of Kelsenite thinking, if you look at Ghana, for example, if you take your constitution, chapter 25, which is headed Amendment of the Constitution. So we have Article 289, 290, 291 to 292. They provide the procedure or the framework for amending the Constitution of Ghana. So if we are going by the reasoning of Hans Kelsen that any illegal change in the constitution of the state represents evolution, then one could argue that any change in the 1992 constitution, not according to the remit, not according to the framework that we have in chapter 23, as I stated, would amount to what they called illegal change in the constitution. That's a revolution. No, I mean chapter 25, not chapter 23, sorry, 25. Yes, that is starting from Article 2892 to 92, provide like the framework for amending various parts of the constitution. Well, as far as Kelsen is concerned, when there is a revolution, the revolution does away or blow away the pre-existing legal regime and replaces it with a new one. So a revolution has been explained as illegal change in the constitutional order or in the constitution. And when it takes place, according to Kelsen thinking, it will destroy the legal order which was in force before the constitution succeeded. And it will replace that with a new one. Do you agree? Is it something you find sensible, or you find this as an artificial reasoning? Do you agree? Do you agree? Put up your hand. I will allow you to speak. Any hand up? Well, let me see. Okay, you can unmute yourself and make sure that you don't leave your mark on or don't allow background noise to come in the class. Okay, so do you agree with the Kelsen's view? Are we communicating?
Yes, Doc, we are with you.
Yes, so do you agree with Kelsen?
I agree. I agree with you. Because if
Can you speak up? If you can be a bit closer to your machine.
So I'm saying that
if you can be a bit closer to your machine, I think that should be fine. Yes.
So what I'm saying is that from what we have heard so far, Kelsen theory is the coup d'etat is an so definitely before an action like this, when it means that those who are problem definitely they are when they succeed in their action, they mean that you are aware.
So talking about a provision, the constitution, and illegally the entire constitution.
Somebody else talking. Are you done? Are you done?
Yes, my lord.
Okay. All right, so let's hear another person. Maybe one female has spoken, so let's get a lead to also. Yes, Socrates. Socrates, go ahead.
Hello, Doc.
Yes, please go ahead.
Hello.
Proceed.
Doc, I think I agree with Kelsen to some extent.
Okay, explain. Explain why you agree with Kelsen.
But might decide a change in a country's constitution. And such a revolution does not result in a change in the country's constitution. So we cannot say that any action that leads to a change in a can be referred to as a revolution. So I think that is where my disagreement will come in. Thank you.
Finnis. All right, thank you very much. Now according to Kelsen, coup d'etats are subsets of revolutions. So he's trying to create a revolution like the universal set or the mother set, and within that, we have coup d'etat. So coup d'etats are a type of revolution that destroys and creates new legal system at the same time. So once the old or the pre-existing legal system is destroyed, automatically it will give rise to a new one. And when a new one has actually emerged successfully, then that is a revolution has taken place. But the most important point he makes, and that's before we move on, when it comes to effect of coup d'etat or revolution, however coup d'etats or revolutions are understood, there tend to be two approaches. What we call the theory of discontinuity and then the theory of continuity. So Hans Kelsen is, if you like, the chief proponent of the theory of discontinuity, that the revolution or the coup d'etat effectively breaks with the pre-existing legal order, and a new legal order is brought into being, so that from the moment of the successful coup d'etat revolution into the future, legal validity of everything is referable to the constitution or to the revolution or to the coup d'etat, as it were. Now, in his work, he propounded a certain concept known as the Grundnorm. According to, he's made the point that where there's a successful coup d'etat or revolution, the pre-existing legal order is actually cleared off, is blown away, and it is replaced with a new one. And within that context, he brings in an idea or a concept known as Grundnorm. And by Grundnorm, he's referring to the primary or the basic norm, which is the source of validity for all the other norms existing in the legal system. In other words, Kelsen developed the idea that if we take any legal system, if we take any legal order, you will notice that the legal rules, what you call them, like the norms, the legal norms, they derive their validity in a successive or hierarchical order. In other words, there is, if you take something like, let's say, an act of parliament, from act of parliament, delegated legislations are made. From delegated legislation, maybe various official acts are done. The police can arrest, this person can refuse to give you license, this person can do that. So all those various actions, those various legal norms, according to Kelsen, they must have validity, and the validity that they have are derived from the next succeeding higher legal rule or norm. So he puts the legal rules or the legal norms in a legal system or a legal order in a form of some kind of like a hierarchy. Hierarchy that is either in ascending order or descending order, but he will even liken the legal system to what we call the collapsible inverted pyramid. If you know pyramid, how pyramid is, so that the apex, usually that the apex of the pyramid, the pointed, it will go into the sky, but he uses the reverse idea of it, that the apex, for example, is down, and then so the apex, as it were, is like the Grundnorm or the basic norm, which gives validity to the next, the next norm, the next norm, the next norm, the next norm. So that is the idea of the Grundnorm. All other norms within the legal system derive their validity from the Grundnorm or the basic norm. Now, if you ask Kelsen, what is this Grundnorm? Where can we find it? Kelsen will say that the Grundnorm is historically presupposed. It is a historical first constitution, which must be presupposed. Presupposed in the sense that it is taken for granted. It is not questioned. And no other norm is higher than it. So the historical first constitution does not derive its validity from any other higher norm. So that is the point being made. Maybe for just want of a better analogy and for convenience of illustration, let's take Ghana's constitution, for example, okay? If we take Ghana's constitution, if we look at Article 1 of the Constitution of Ghana, we have looked at it and it reads, the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of the government are to be exercised in a manner indeed laid down in this constitution. Now, if you go to the other provisions, we told about the supremacy doctrine, that this constitution, all laws must be in agreement with this constitution. So the question is, beyond this constitution, does this constitution derive validity from any other law? Maybe it's debatable, but if you are thinking in Kelsen terms, Kelsen will say that the Grundnorm or the basic norm is a historical first constitution whose existence is taken for granted or presupposed. And in the sense that it does not itself derive validity from any other. However, from that Grundnorm, that basic norm, will all other norms derive their validity within the legal system. And this has got a certain implication, because if the Grundnorm is a basic norm which gives validity, then if that Grundnorm is blown away, it follows that all the other norms that derive their validity from the Grundnorm would also cease to have validity. So that is the kind of logic Kelsen is advancing with this Grundnorm concept. So then the basic norm in Kelsenite thinking is the ultimate norm. It's the ultimate norm in the sense that it gives validity. It is a reference point for validity. It is a baseline. It's a benchmark. No other norm can have validity on its own without going back to this Grundnorm. So the Grundnorm that is presumed to be valid. In other words, its validity is not questioned. Its validity is presupposed. And as we have said, all other norms derive their validity from it and must conform to it. The Grundnorm we have stated in Kelsen thinking is presupposed because it's not the creation of any law-making institution or body. It's not any law-making institution or body which brought the Grundnorm into existence. So that is a point to keep in mind. So therefore, the validity of the Grundnorm is not premised or hinged on the basis of its creation, like maybe how some institution or body actually made it. No. Its validity is presupposed. Its validity is taken for granted. And it is so. It is so presupposed because without that, no act can be deemed to be legal. And that is why we have to start from somewhere and assume that where we are starting from, has validity in itself. And it doesn't depend on any other thing for validity, as it were. So question is, who presupposes the Grundnorm? Kelsen will say, and I quote, the basic norm is presupposed by whoever interprets the subjective meaning of the Constitution, creating acts and of the acts created according to the Constitution, as objective meaning of these acts, that is, as an objective valid norm, unquote. So, in Kelsenite thinking, the Grundnorm is not a concrete reality, because as you can see, he is making the point that the basic norm or the Grundnorm being presupposed or being taken for granted as existing and being valid in its own rights is a conclusion that you come to as you appreciate the external reality of the working of the Constitution. And as we have said, Kelsen makes the point that the basic norm is the historical first Constitution. It's not necessarily that was first in time, so let's keep that in mind. So being the historical first Constitution does not necessarily mean that it is a Constitution which is first in time. No. It does not also refer to the oldest Constitution that one can discover, not the first written Constitution. So it is tempting for us to say that, well, if Kelsen is saying that the Grundnorm or the basic norm is the historical first Constitution, which is presupposed, then it must be the very first Constitution that Ghana had. So that if we are talking about Ghana, people may even go to the sense of thinking of the bond of 1844, which legally allowed the colonialists to start colonizing our people. And gradually we develop, we get the 1876 ordinance, various constitutions will come, and ultimately the independence motion is tabled in Parliament, and we have the 1957. Somebody may go on that trajectory, but that is wrong. That is not what Kelsen is saying. The Grundnorm is a reference to an initial constitution or organic law. Organic law created in a way not anticipated by its predecessor. So that is the Grundnorm. Of course, I appreciate the difficulty that you may have with intellectual appreciation of it, because the way Kelsen is talking brings in a bit of like sophistry, a bit of even like a metaphysical reason instead of concreting, is more into abstraction. Yes, I appreciate that. So don't worry about that. We just want to expose you to just a little aspect of his thinking for purposes of coming back to the question, what is the legal effect of coup d'etat or revolution on a constitutional order? So from what Kelsen has told us, that the historical first constitution, which is the Grundnorm, is presupposed, it follows that any norm purporting to the Grundnorm or the basic norm, which comes about or is anticipated by the existing initial law or constitution, cannot purport to be the basic norm, because it's saying that even the predecessor should not have anticipated that this Grundnorm will emerge or this basic norm will emerge. So the validity of the new norm is determined by the existing norm. Now, can we have a change of the basic norm? Is it possible to have a change of the basic norm? Well, Kelsen in his work will make the point that, quote, it is just the phenomena of revolution which clearly shows the significance of the basic norm. And I will give illustration. Suppose that a group of individuals attempt to seize power by force in order to remove the legitimate government in a hitherto monarchic state and to reintroduce a republican form of government. If they succeed, if the old order ceases, that is the monarchical government or state ceases, and the new order, that's the republic, begins to be efficacious because the individuals whose behavior the new order regulates actually behave by and large in conformity with the new order. It is now according to this new order that the actual behavior of individuals is interpreted as legal or illegal. But this means that a new basic norm is presupposed. It is no longer the norm according to which the old monarchical constitution is valid, but the norm according to which the new republican constitution is valid. A norm endowing the revolutionary government with the legal authority. If the revolutions fail, if the order they have tried to establish remains inefficacious, then, on the other hand, the undertaking is interpreted not as legal, a law-creating act, as the establishment of a constitution, but as an illegal act, as a crime of treason. And this according to the old monarchic constitution and its specific basic norm, unquote. In other words, Kelsen is giving us a blueprint, is giving us the test for understanding how the Grundnorm comes about. And that is why he's using the illustration of, let's have a country which is monarchical. In other words, a country which is ruled by a king or a queen. That is the type of constitution that they have. And some people want to change that order and say that we don't want a king, we don't want a queen. You want to have our own precedents that we elect. So we want to have a republican government. Now, where these people embark upon initiatives or efforts to overthrow the monarchical government and replace it with the republican government, if they succeed in destroying the monarchical system, and the people in the society, the people in the state, if they obey those that sought to destroy the old system, and subsequently they order their affairs according to the dictates or according to what the change makers, as it were, are actually prescribing, then what it means is that the new system has become largely efficacious. We have efficacy, some effectiveness. And for that matter, Kelsen will say that the old system has been blown away, and there's a new system. There's a Grundnorm, a new Grundnorm, which gives validity to all other acts. So that from that moment going, as whether someone has done something which is acceptable or not acceptable, we make the determination of the acceptability or the illegality of it according to the standards prescribed by the new order. Those who brought about the change, they will become like the reference point, as it were, of what is valid and what is not valid. So the takeaway is that as whether a revolution is successful or not, Kelsen will talk about efficacy. Is it generally efficacious? If it is generally efficacious and the individuals in the society or the state conform their behavior according to the new order, and that they feel themselves, if you like, bound by the new order, then what it means is that the change has been efficacious. So there's a new Grundnorm, as it were, in place, which will give efficacy to all other norms within the legal system or the legal order. Now, this way of thinking, which Kelsen has espoused, is what we call the theory of legal discontinuity. The theory of legal discontinuity in terms of what happens when there has been coup d'etat or revolution vis-a-vis the pre-existing constitutional order. So Kelsen says that by this theory of discontinuity, where the revolution or the coup has been efficacious, in the sense that individuals no longer conform their behavior to the old system, but they conform their behavior to the new system, then what it means is that by and large, it has been successful and the new Grundnorm will have come into place. And all other official acts, all other norms will now have to derive their validity from this legal norm. And the old system is completely blown away. And that is why we call it the theory of discontinuity. That is to say that coup d'etat or revolution does not allow the pre-existing legal order to continue. It rather discontinues it. It makes a clean break with it. So if you look at coup d'etat or revolution, however you call it, when it is made, the leaders will often come out with, using Ghana as an example, what we call establishment proclamation. They will come out with their proclamation, like they will craft their own statement and try to let that statement be the new source of, if you like, authority or validity. So if you take Rawlings, when he came at in June 4th, they established what they call the Armed Forces Revolutionary Council Establishment Proclamation. And those days, you know, they go to the radio and read this. The constitution is suspended, all government dissolved. You know, the executive, this is dissolved. The council has been put in place. Then they read that out, make a national broadcast, record that the establishment proclamation, trying to say that you have established a new system, and it is the new system which gives validity to everything. Similarly, if you take the Armed Forces Revolutionary Council Establishment Proclamation, it's, if you go and read it, it suspended the 1979 Constitution. That was the pre-existing, if you like, the constitutional order. In the same vein, not the 79 Constitution was suspended by the PNDC, not the Armed Forces Revolutionary Proclamation, because the June 4th was actually a revolt against a military government. Yeah, but it was the PNDC proclamation which suspended the 1979 Constitution. So let us keep that in mind. But before we continue, I want you to look at Article 3 of 1992 Constitution. Article 3 of 1992 Constitution. Somebody should read that for us. Especially Article 3 clause 2.
Of this article by the Supreme Court shall duly obey and carry out the terms
Article 3 clause 2. Defense of the Constitution. 3 clause 2. I mean Article 3, not Article 2. Article 3 clause 2.
Article 3 clause 2. Any activity of a person or group of persons
which suppresses or seeks to suppress the lawful political activity of any other person or any class of persons or persons generally is unlawful.
Good. Continue. 3. Sub 3.
Any person who, A, by himself or in concert with others, by any violent or other unlawful means, suspends or overthrows or abrogates this constitution or any part of it, or attempt to do any such act, or B, aids and abets in any manner any person referred to in paragraph A of this clause, commits the offense of high treason and shall, upon conviction, be sentenced to suffer death.
Okay, so you notice that Article 3, clause 3 is trying to say that, well, we do not recognize any possibility of successful revolution or coup d'etat. And if you attempt and you are not successful, but of course, this provision itself is also contingent upon what the Kelsen is saying. What about if those who sought to overthrow the constitution, if they succeed? If they succeed, so what happened? What happens to then clause 4 will say that all Ghanaians, all citizens should continue to resist those who attempted to overthrow the constitution. That every Ghanaian should defend the constitution. And if it will mean even killing those who overthrew the constitution, so be it. And if you suffer any loss, when you have succeeded in restoring the constitution, you can go to Supreme Court, and then the Supreme Court will make orders which will enable you to get appropriate reward or compensation, as the case may be. But we come back to this later on. So what we have said so far is that Hans Kelsen is the chief proponent of the theory of legal discontinuity as far as the effect of coup d'etat on pre-existing constitutional order is concerned. We'll look at some case law, but before that, it is pertinent to also recognize that we have other scholars who don't subscribe to the theory of discontinuity, and for that matter, may probably be seen as supporting continuity of the pre-existing constitutional order. That if there is the so-called coup d'etat revolution, it doesn't actually destroy the pre-existing constitutional order, and it will somehow continue to remain in force. So one of such thinkers is John Finnis. So John Finnis will identify 3 categories of constitutional rules to support his opposition to Kelsenite reasoning that where there is a successful revolution or coup d'etat, it destroys the pre-existing legal order. So Finnis would identify rules of succession to office. There are some constitutional rules are actually rules of succession to office. Some are rules of competence. Some are rules of succession of rules. So rules of succession to office, for example, will include rules in the Constitution which govern accession to and succession in office. In other words, how people come to public office. Those rules are called the rules of succession to office. So if you take Article 62 of our Constitution, for example, we are told in the case of like the executive, you know, how Article 62, 63, election of the president. And then if the president is, you know, unavailable and so on, how somebody should act. If you look at Article 60, the vice president and so on, you can succeed the president. So these are all rules of what? Succession to office. Then we also have rules of competence according to Finnis. That's another category of constitutional rules. And these are the sum total of the rules which govern the distribution of power in the state. So the various organs of government, how they are set up, the powers that they are endowed with, and of course, the relationship between them, what they call separation of powers and checks and balances. These are rules of what? Of competence. So look at Article 58, the executive power authority is vested in the president. You look at Article 93, legislative power is vested in the parliament. You look at Article 125, final judicial power is vested in the judiciary. Then we also have rules of succession to rules. And this category of constitutional rules, according to Finnis, will include those, whether they are included in the first two categories we talk about, which govern the amendment, suspension, or replacement of rules of each of these three categories. So how the Constitution is amended, for example, we talk about Chapter 25, if you remember. Chapter 25, which provides the procedure for amendment of the Constitution, will fall under the rules of succession to rules, as it were. So the rules of succession to office can legally be altered. And when this is done, the presumption is that it is done pursuant to the rules of succession of rules. Like if we say the rules of succession to office, for example, how the executive, how the president is elected, or the qualification of president and so on. They are entrenched, but those provisions are not cast in stone. They can be amended if you bring yourself within the appropriate amendment framework under Chapter 25. That is starting from Article 289 to 292. You can get it amended. So that is possible. So in the same vein, we can also get the rules of competence also amended, except that it's only the legislature that can get all these things done. So according to Kelsen, when can we say that there's a revolution then, in terms of his way of reasoning, having put constitutional rules into three categories? In Finnis, we are not talking about Kelsen, we are talking about Finnis. In Finnis's thinking, if there is a revolution, it affects all the three categories of rules. So when all the three categories, that is the rules of succession to office, rules of competence, rules of succession of rules, where you get an intervention which effectively affects all these three categories, then you can say that evolution has occurred in terms of the Constitution. Well, I don't know whether you agree with Finnis. Do you agree with Finnis? Any thoughts before we move on? Anybody? Do you agree with Finnis? So Finnis is saying that before we can say that a revolution has occurred, all the three categories of constitutional rules that he has identified should have effectively been altered. And my question is, do you agree? Any thoughts? As I said, when we're having a class, don't be shy to speak. Whatever you say is correct because we are learning. Okay? We don't want to talk. Let's continue. Okay, so let's look at some cases. If you look at the case law, that will give us a review of this legal effect of coup d'etat that we are talking about on the pre-existing constitutional order. Maybe let's start with our own Sallah versus Attorney General. Sallah versus Attorney General, very, very interesting case, and if you haven't read it after this class, I expect that you go and read Sallah versus Attorney General. Has anybody read it, by the way? Has anybody read Sallah versus Attorney General? Anybody? Well, Mr. Sallah, who was the plaintiff in this particular case, was a manager in the different Ghana National Trading Corporation, what we call the GNTC. And this GNTC was established under a statute, under an act of parliament, which was passed before the 1966 coup d'etat. I'm talking about the first coup d'etat in Ghana. And it was that coup d'etat which brought the NLC, National Liberation Council, into power. Mr. Sallah was appointed in 1967, that is after the 1966 coup d'etat. And the position that was appointed to was a position which already existed in the GNTC, the corporation, before the coup d'etat, because the GNTC was already there. It was established by Nkrumah. So the managerial position that was appointed was a position which existed already before the coup was made in 1960. So he was appointed to replace an employee who retired from the corporation on health grounds. Now, having been appointed in 1967, I mean, barely a few months after the coup had been made, in February 1970, Mr. Sallah received a letter from the office of the head of state. Of course, we didn't have a president then. I mean, no, sorry, office of the president. That is the second republic having just started with Buzia and Edward the Kufuor as the president. And the letter sought to relieve him of his position as a manager of GNTC. Well, this was part of the various dismissals which the government that came into power in 1969 was doing, the famous Apollo 568, if you remember that in Ghana history. The letter, which sought to inform him of his dismissal or removal from office, somewhat sought to inform Mr. Sallah of the effects of Section 9, Subsection 1 of the transitional provisions of the 1969 Constitution. So mind you, these transitional provisions we have in the 1992 Constitution is not new. We started way back, from 1969 because there have been a coup d'etat. So when we're returning to constitutional governance, it was necessary for us to manage how to transition seamlessly from the various troubles we've had by reason of the military intervention, the new democracy that we're returning to. So we had that. So the letter sought to bring Section 9, subsection 1 of the transitional provision of the 1969 Constitution to its attention, as it were. And if you look at it, among other things, it stated the following, that subject to the provisions of this section and save as otherwise provided in this Constitution, every person who immediately before the coming into force of this Constitution hold or was acting in any office established. So the emphasis here is on the word established. Let's pay attention to that. Established, A, by or in pursuance of the proclamation for the Constitution of the National Liberation Council for the administration of Ghana and for other matters connected therewith, dated 26th day of February 1966, or in pursuance of a decree of the National Liberation Council, or C, by or under the authority of the Council, shall, as far as consistent with the provisions of this Constitution, be deemed to have been appointed as from the coming into force of this Constitution to hold or to act in the equivalent office under this Constitution for a period of 6 months from the date of such commencement, unless before or on expiration of that date, any such person shall have been appointed by the appropriate appointing authority to hold or to act in that office or some other office. So, simply put, the provision that we have quoted was saying that, yes, if you are holding a public office, and a public office that you are holding was affected by Section 9(1) of the transitional provision, in the sense that your office was established by the proclamation, the establishment proclamation of the NLC, of the National Liberation Council, that is the coup makers of 1966. You know, they issued the establishment proclamation. Now, if your office or the position that you hold was established by that establishment proclamation of the 1966 coup makers, the National Liberation Council, then according to Section 9, subsection 1 of the transitional provisions of the 1969 Constitution, following the coming into force of the 1969 Constitution, you have been given 6 months to remain in office. And if at the end of 6 months, you have not been reappointed by appropriate authority, then you are deemed to have finished your service and you have to go home. So this was a provision in the 1969 Constitution. But the problem with Mr. Sallah was that, yes, Mr. Sallah was appointed in 1967. The coup was made in 1966. But the position that he was appointed to go and hold is a position which was established by a law made long before the coup. The position in the GNTC was established by a law made in 1961. And the Executive Instrument 203, EI 203. And the GNTC itself had been established by the Statutory Corporations Act of 1961. So the position, the job which Mr. Sallah had been appointed in 1961 to go and hold, was it established by the proclamation of the coup makers, or it was not established by that because it was already there before they made the coup? If it was not established by the proclamation of the coup makers, what it means is that Mr. Sallah will continue to hold his office, because in that case, Section 9.1 of the transitional provision will not apply to him. On the other hand, if you take the view that his position was actually established by the proclamation establishment of the National Liberation Council, then according to the plain and ordinary meaning of Section 9, subsection 1 of the transitional provision of the 1969 Constitution, as we have quoted, Mr. Sallah was on his way out if at the end of the 6 months he was not appointed. So that was the scenario. Yeah, so certainly Mr. Sallah and his lawyers will make the argument that the office that he was occupying did not fall within the various categories of offices mentioned in Section 9.1, that is, as having been established, first one to the NLC Establishment Proclamation. Now, the relevance of Sallah versus Attorney General to what we are talking about is that now, what is the effect of the NLC, the National Liberation Council Establishment Proclamation, on the pre-existing legal order, the 1960 Constitution, the various laws which existed and all that? What was the effect of this National Liberation Council proclamation, establishment proclamation? If you subscribe to the view that the successful coup d'etat of 1966 effectively destroy the pre-existing legal order, then you will be saying that the office that Mr. Sallah occupied was established by the proclamation, because the proclamation which has given recognition, or if you like, effect to it. On the other hand, if you take the view that the office was there and is not any NLC proclamation which brought it into being, in that case, Mr. Salah's office was not established by first one to the NLC proclamation, so he's not affected by Section 9.1 of the transitional provision. So that was the state of affairs in that particular case. What is interesting in that case is that the Attorney General at the time, representing the state, argued on behalf of the government that the suspension and subsequent abrogation of the 1960 Constitution following the 1966 coup d'etat had the effect of rendering all acts made under the 1960 Constitution as having lapsed. In other words, the Attorney General was using Kelsen's theory of discontinuity to argue that insofar as the 1966 coup had been successful, had been efficacious, then all laws that predated it should be deemed to have ceased to have any force of law, and any legal validity was referable to the NLC, the National Liberation Council Establishment Proclamation. So if the Attorney General is arguing that way, in that case, the legislation, that is the the 1964 Statutory Corporations Act, under which an LI was passed and the GNTC was actually established and the position of manager was created and all that, will be deemed to have all been actually blown away. They've lost their validity. So the Attorney General invited the court to interpret the word established. If you remember, if you look at the Section 9.1, if you can see where my cursor is, like that the word established here, like so whether the office was established, the Attorney General invited the court to interpret the word established to mean deriving legal validity from. So if it means deriving legal validity from, then he wants to contend that the office which Mr. Sallah was occupying did not derive its origin from the 1964 legislation and all that. It had been allowed to continue by reason of the National Liberation Council establishment proclamation, in which case Mr. Sallah is caught by Section 9.1, because Section 9.1 says that anybody occupying an office which was established by or pursuant to the National Liberation Council proclamation will have 6 months to continue to hold his office following the coming into force of the new constitution, unless the person is actually reappointed. And if that is so, then Mr. Sallah had to go home, as the letter was saying, because yeah. So this was the argument by the Attorney General. Of course, that argument, the Kelsen reason, was not really received by the court. As Zapalu, for example, will react this way, and I quote, "I believe members of the Constituent Assembly approach and perform their tasks as practical men of business, guided by the experience of our recent past and informed by an understanding of ordinary English words. I cannot accept that in using the word established in Section 9.1, they had in mind any juristic theories on the principle of legitimacy. If that be right, it will be subversive of their intention to interpret their declared will by reference to any such theory." I mean, in other words, Justice Apalu, who was part of the Supreme Court, which decided the service of the saying that we don't have to read exotic theories from Kelsen into the minds of the framers of the Constitution when they put the transitional provisions there, and in particular, Section 9.1. And they should be taken to have actually meant simple what it just says, informed by the recent experiences of the country Ghana. So he sort of rejected the reliance on Hans Kelsen theory by the Attorney General. Then he continues, "This contention seems to me highly artificial, and I cannot believe that with the known pragmatism that informed judicial attitude towards questions of legislative interpretation, the Attorney General have thought an argument as this was likely to carry seasoned judicial minds. We should fail in our duty to effectuate the will of the Constituent Assembly if we interpreted the Constitution not in accordance with its letter and spirit, but in accordance with some doctrinal juristic theory." So the judge or the Supreme Court still castigating the Attorney General for trying to invite the courts to use Hans Kelsen's theory on coup d'etats and revolutions to interpret a constitutional provision, in this particular case, the word established in Section 9.1 of the transitional provisions of 1969 Constitution. Similarly, Justice Sowa, who was also on the Supreme Court, also had this to say, and I quote, "It seems to me a far-fetched interpretation to say that by these words, the National Liberation Council was re-establishing or creating anew all the laws of Ghana, including the common law and customary law. A true interpretation is that those laws in existence should continue, subject, of course, to subsequent decrees that might be promulgated." So, Justice Sowa was saying that the National Aviation Council Establishment Proclamation should not be understood as having abolished all the laws of Ghana. Rather, because he gave example, Ulu said that has also changed the common law. The common laws like case law, decided cases. Has it changed our customary law? He said that no. And if the answer is no, then what it means is that the better way to understand the Establishment Proclamation is that it's rather allow all the laws to continue to remain in force until such time as the new government may deem it fit to make changes, and then changes are made. And I think that seems to be consistent with what really happens. So Kelsen's reasoning is too not only abstract, but too unrealistic. Then Justice Enin, who was also on the panel, had this to say, quote, notwithstanding the fact that public offices which were in existence prior to the coup bore practically the same name before as after the coup, the true legal position is that these public offices and services were the creation of the National Aviation Council, and they existed by virtue of and in pursuance of this proclamation, and in certain specific cases, in pursuance of subsequent NYC decrees. So if you look at the ending, you see a little bit of like a subtle reception of Hans Kelsen's reasoning. We also have like the other cases, like the case of Michel versus DPP. Michel versus DPP, for example, is a case which arose in the, what do you call it, the Grenada. This was 1983. There had been a coup d'etat, and the coup d'etat led to overthrow of Prime Minister Maurice Bishop government, and he was executed, and other violence occurred. So the Governor General of Grenada requested intervention of Organization of Eastern Caribbean States, maybe similar to what we have, maybe like the ECOWAS, but this is the Southern America, the Latin America, and the United States. So the US and Caribbean forces intervened and succeeded in overthrowing the military junta that had assumed power. So that was the state of affairs. So a coup had been made, and later on, the coup makers are also dislodged from power. So in this particular case, Andy Mitchell, who was an appellant or among the appellants in the case, were part of the revolutionary government, the government led by the People's Revolutionary Government, PRG, that had overthrown the prime minister. Now, after intervention and restoration of democratic government, they were arrested, and the Mitchell were arrested, and his other people were arrested for having played their role in the previous coup d'etat, including murder of the prime minister. So a court was constituted by the new government. That is the government which was set up after the invasion and restoration of proper government. And the court convicted the appellants, Michel and Co. of murder, and they were sentenced to death. Now, they appealed right up to the Privy Council. And the Privy Council, for most British colonies, is the highest appellate court. So in appeal, Mitchell and the other appellants put up the argument that the court which tried them was not legally constituted under the Constitution of Grenada because the country was under state of emergency and normal judicial proceedings have been suspended by the revolutionary regime. That is those who did the coup. And the appellants argue further that the legal framework and the constitution have been disrupted by the coup. And for that matter, their trial under the restored order was unlawful. So just trying to reason along a case in that, yes, when we had the coup, we destroyed the pre-existing constitutional order. And if the pre-existing constitutional order has been destroyed, then despite the intervention and restoration of a new government, the old system is no longer there. So you cannot set up a court under the old system and expect us to be tried and be convicted by that court. So that was the argument. So the critical issues was whether the court that convicted Andy Mitchell and the other appellant was lawfully constituted, given the circumstances under which the Grenada's constitutional framework was disrupted by the coup and the subsequent intervention. So the legal proceedings and the conviction of the appellants, were they valid in the context of the aftermath of the coup? Especially because, mind you, yes, the coup has been successful, but the coup has also been countered subsequently. And proper, if you like, or democratic government has been put in place. The Privy Council, which, as I've told you, is the final appellate court for Grenada, held. Just a minute. Held that the convictions of the appellants were valid. In other words, the court rejected, the tacit reliance on Hans Kelsen's theory of discontinuity. So, in the view of the court, the Privy Council, the court will try them have been properly constituted under the restored legal framework. And the Privy Council further took the view that even though the Constitution of Grenada had been temporarily disrupted by the coup, the legal order had been restored with the intervention and re-establishment of a lawful government. So the court did not accept the argument of the appellant that their convictions were unlawful just because of the coup d'etat which they made before the restoration took place. And in the view of the Privy Council, the judiciary, once reconstituted under the legitimate government, had the authority to try and convict the appellant for the crimes they have committed during the revolutionary period. So Hans Kelsen, again, did not succeed on this occasion, just as his theory did not succeed in Ghana to Sallah as Attorney General. But let's look at maybe some other cases. Uganda against Commissioner of Prisons, ex-party Matovo. That is a Ugandan case. Matovo was arrested during military regime in Uganda after a coup led to overthrow of the government. The new government had issued decrees which sought to override the old constitution. So Matovo applied for the writ of habeas corpus. You know, habeas corpus is a remedy you usually go for where you have been maybe arrested or detained without any lawful authority. Then habeas corpus means that produce a body. So you have to come to a court of law and show cause why the person you have detained should not be released. So habeas corpus. So Matovo applied for habeas corpus and claimed that his detention was unlawful under the constitution that existed before the coup. So here, there's a coup, you've been arrested under the military regime. Now you go to court and you try to rely on the constitution, which predated the military regime, to challenge your arrest and detention. So the critical issue was whether the pre-existing constitutional order had any continuing validity after the coup, and whether the court could recognize legality of the new regime and its decrees. So just a bit of a context more. 22nd February 1966, the Prime Minister of Uganda issued a statement and declared this, quote, "In the interest of national stability and public security and tranquility, we are taking over all the powers of government of Uganda." So this is like the coup d'etat that we are talking about. Now the courts made the following observations regarding developments in Uganda when the situation in Espat Matovo was presented before it. Quote, "We hold that the series of events which took place in Uganda from February 2022 to April 1966, when the 1962 Constitution was abolished in the National Assembly and the 1966 Constitution adopted in its place, as a result of which the then Prime Minister was installed as executive president, could only appropriately be described in law as a revolution. These changes had occurred not in accordance with the principle of legitimacy, but deliberately contrary to it. There were no pretensions on the part of the Prime Minister to follow the procedure prescribed in the 1962 Constitution, in particular for the removal of the President and Vice President from office. Power was seized by force from both the President and then the Vice President. Then the court continued. Our deliberate and considered view is that the 1966 Constitution is a legally valid Constitution and the supreme law of Uganda, and that the 1962 Constitution, having been abolished as a result of a victorious revolution, in law no longer exists, nor does it now form part of the laws of Uganda, it having been deprived of its de facto and de jure validity, unquote. So effectively, the court was welcoming the theory of discontinuity, that a successful coup d'etat or revolution has actually done away with the pre-existing legal order. So that is ex parte Matovo. Now, ultimately, the court applied the principle of doctrine of state necessity and ruled that the new regime had effectively displaced the old constitution, the 1962 Constitution. And for that matter, the doctrine of effectiveness, that is effectiveness similar to what the Kelsen said about efficaciousness, meant that the court had to recognize the new government's authority, even if it came to power through unconstitutional means. Therefore, application for habeas corpus was denied, because the application for habeas corpus was brought pursuant to the old constitution, which the court has acknowledged has effectively been overthrown or dislodged by the successful revolution, as it were. We also have the case of Mazmabuto against Lagnabek, an interesting case from modern day Zimbabwe, which used to be called the Rhodesia. No, you might have heard of the Unilateral Declaration of Independence by Ian in Southern Rhodesia, now Zimbabwe. So the Rhodesian government declared independence unilaterally, that is without engaging the colonial government and so on and so forth, and proceeded to enact new laws. And the laws they made were not consistent with the constitution, which was still recognized by the British government. Mazimabuto was arrested and detained under Rhodesian law, and he sought to challenge legality of his detention. So he decided to fight it right up to the Privy Council. And the Privy Council came to the conclusion that despite effectiveness of the new regime, following the Unilateral Declaration of Independence in Rhodesia, it was not lawful because it had not been recognized internationally. So the British Court, the Privy Council, is now introducing a new element that the Unilateral Declaration of the Independence has not been recognized internationally. And for that matter, it should not be seen as having succeeded in doing away with the old or the pre-existing constitutional order. Consequently, the pre-existing constitutional order remained valid, and the laws of the new regime were declared unlawful. So that is this contrast with Espat Matovo. So Mazmabuto against Lagnabek, sort of goes back to the theory of discontinuity. Of course, if you look at the reasoning in Mazmabuto and Lagnabek, the court is not, if you like, completely closing its eye to the theory of discontinuity or continuity. But let's listen to what Lord Reid. Lord Reid was part of the panel who sat at the Privy Council over Mazmabuto and Lagnabek. I quote him: "It is an historical fact that in many countries, and indeed in many countries which are or have been under British sovereignty, there are now regimes which are universally recognized as lawful, and which derive their origins from revolutions or coups d'etats. The law must take account of that fact. So there may be a question of how or at what stage the new regime became lawful. The issue in the present case is whether emergency powers regulation made under the 1965 Constitution can be regarded as having any legal validity, force, or effect. Their lordships would therefore humbly advise Her Majesty that it should be declared that the determination of the High Court of Southern Rhodesia with regard to validity of the emergency powers regulation made in Southern Rhodesia since November 11, 1965 is erroneous, and that such regulation have no legal validity, force, or effect." So that is the decision of the Privy Council in Mazmabuto and Lagnabek. But if you look at the reasoning of Lord Reid, if you look at where the cursor is, he says something that there are now regimes which are universally recognized as lawful, but which derive their origin from revolution or coup d'etats. So the court was saying that, yes, we need to be realistic and acknowledge that if we look around the world, there are some regimes which came to power through coup d'etat. By and large, they have been recognized by other states, and other states engage business with them. So we cannot close our eyes to that. However, we need to find out how and at what stage can the new regime become lawful. And the court was just impliedly saying that, yes, what took place over there has not been recognized by other countries and so on. And for that matter, it was not effective. Now, in Pakistan too, there was a case of Tate against Dosu. There had been a coup d'etat by General Khan in 1958 in Pakistan. And following the coup d'etat, they established a martial law. So the respondent in this case, Hussein Dosu, challenged legality of the military takeover in the Supreme Court of Pakistan. And the appellant, that is the state of Pakistan, defended the actions of General Khan and sought validation of the military regime. So the court, among other things, needed to find out constitutionality of the coup d'etat and whether the martial law, which is established subsequently, is a valid one. And the court also addressed the issue of the doctrine of necessity. And then I want you to pay attention to that doctrine, the doctrine of necessity in constitutional law. So the court analyzed the history and development of the doctrine of necessity. If you read the full judgment and examine cases from various jurisdictions, and the court recognized that in exceptional circumstances, where there is a threat to the stability and security of the state, the doctrine of necessity should be invoked to validate a non-constitutional act. So, in appropriate cases, the doctrine of necessity can be invoked to justify that which ordinarily appears to be unconstitutional. The court also examined the constitutional framework of Pakistan and the provision related to suspension of fundamental rights and powers of the president. And ultimately, the court came to the conclusion that the doctrine of necessity could be invoked to validate a non-constitutional act if it was deemed necessary for the stability and security of the state. So in this particular case, it was a court view that the military coup d'etat and the establishment of martial law, adoption of martial law, were justified by the doctrine of necessity. Because in the court's view, there were exceptional circumstances, or we had exceptional nature of situation, which included the need to avoid chaos. So if declaring martial law would save the country from plunging itself into abyss of chaos, then despite the fact that martial law ordinarily is unconstitutional, could be regularized by reference to the doctrine of what? Necessity. Of course, the court acknowledged that the martial law should not be forever. It should be temporary to solve a problem as it were. Good. So I will take questions before I draw the curtain down. Next week, we will start discussing the constitutionalism and then the separation of powers. When we meet in person, okay, in absence of any indications from your end, have a good night.
Goodbye.
Good night.